Welcome to Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. This week, we look into the King versus Burwell Supreme Court case, the latest challenge to Obamacare. In the second half of our show, we'll speak with Carrie Severino, Chief Counsel and Policy Director for the Judicial Crisis Network, to poke into the recently completed oral arguments trying to understand how the Supreme Court might rule. Up first, we welcome Thomas Miller, Resident Fellow at the American Enterprise Institute, to look at some of the broader substantive and political issues surrounding the case and its possible impact on executive branch powers and the rule of law. Tom, welcome to the show.
Pleasure to be with you, Bill.
Tom, the Supreme Court is deliberating on King versus Burwell, the, of course, most famous Obamacare case we're dealing with. And I thought it'd be a good time to sit back with you and review some of the larger issues. Remind us what's at stake.
Well, what's at stake in the immediate sense is how your health care operates and the rules for it and what's coming and going out of different people's pockets and what we're going to have looking ahead to that.
A lot of practical issues.
This has been an unusual law, which we're going past the 5-year mark. Now, the legal issues, it was a series of lawsuits. One finally made it all the way up to the Supreme Court, and that's where we'll hear what the court's ruling is not a revisiting per se of the old constitutional issue from 2012, the individual mandate, and was this, does the federal government have the power to do this? This is a statutory construction case about what administrative rule. The Internal Revenue Service actually passed this. This administration has passed a lot of rules, and sometimes they're interim guidance, sometimes they're blog posts, sometimes they're tweets. Sometimes, if you don't like the old rule last week, we'll give you a new one tomorrow. So there's a long history of that. But in this particular case, there was a provision in the law that set up some of the working rules for these. They used to be called exchanges. Now they're called marketplaces. They don't look like marketplaces. And there's ones for state-run exchanges. And then they had to put in a backup plan for federal-run exchanges in a different part of the statute. But the key ingredient is there's 4 important words in the most direct part of the statute, which deals with whether you can subsidize these exchanges and then how you subsidize them and what the amount is. And in that section of the law, it's pretty clear-cut that they refer to these subsidies being determined in exchanges established by a state. And those are the magic words.
So just pause a moment here, because the constitutional issue is, what does the law say, what does the law mean, and who can interpret it?
In that sense, it's a separation of powers issue in the broader sense. That's not immediately in front of the court. We think that under the Constitution, the old Constitution, the one that people remember vaguely, Congress passes laws, the executive branch administers them faithfully. That's been stretched in the modern era. It's been stretched even more and attenuated and wider by this particular administration, which says that's an interesting suggestion from Congress, but we'll move on and go ahead and implement the law the way we feel like. So in the pure sense, you could argue that that's unconstitutional, but that's not the claim being made in court. The claim being made in court is, let's enforce the law that Congress passed. Not what they say later on, but the law that was actually approved by the Congress in March of 2010.
And what exactly did the IRS do to earn the ire of the plaintiffs in this case?
Well, they had a long rap sheet before that, but the most immediate offense that's currently before the arraignment. The quick history of this is the law is passed in a rush. Sometimes the phrase we use is the last helicopter out of Saigon. They couldn't clean it up. They had to swallow the Senate law of that bill the way it was written. Oh, there's a lot of mess on that front. But subsequently, when people actually got around to reading the law, which probably the members voting on it didn't to a large extent, their staff wrote it in a hurry, or maybe they didn't read it either.
I think they bragged about it. Didn't they say we had to pass it to find out what was in it?
That would be former Speaker Pelosi. It was a great discovery process to know what was in it. I mean, our own direct role, I'm at the American Enterprise Institute. We held a forum in December of 2010, and an excellent attorney I've worked with subsequently in a lot of roles, Tom Christina, had read the law. He's a benefits attorney. He can actually do these things. And said, you got a problem between this one part of the section and the other. That's the first moment above ground where someone said there might not be any money connected to these federal exchanges. Small detail. Now, that's only still a hypothetical until you know this is such a complex law that they have all kinds of things they didn't have to do to implement it. That's why I remember it was like about 4 years before you actually had everything fully unpacked.
But that's common
for
most laws now. There's an expansion of 10, 100 to 1 between the pages of law and the pages of regulation. Doesn't that go on all the time?
Well, it was an economic stimulus for the legal profession in order to, you got to give them work somehow.
But that's business as usual in Washington. There's nothing particularly unconstitutional about that, is there?
Usually you don't promise people something and only deliver it 4 years later, though, all the benefits and the goodies. So because what they were trying to do, they couldn't really do, maybe ever, but certainly in a hurry. And there was a lot of these provisions of the law. The secretary shall, lots of extra, fill in the blanks, discretion type thing. In this case, our contention would be the secretary didn't have a lot of discretion at all. The law was what the law said. If a state decided to set up an exchange, they would be subsidized, and the tax credits for basically buying the coverage there. It actually goes to the insurance company after all's said and done. And if the federal exchanges were set up as a backup, there wasn't any money attached to it. Now, the IRS began a process, and they started a rulemaking, and the lower level people thought, well, geez, we can't do this. I mean, this is what the law says, and we're going to have to do it this way. And then the political people said, just a moment. It's only a suggestion from Congress. I'm not using their exact words. We can get something through on this. And so by late 2011, in the fall, we got an inkling that the IRS was going to be bold enough to say creative. The law was different than, it's close enough for us to do something with it. The final rule, though, actually wasn't approved, despite some comments saying you don't really have authority for this. What's your evidence for it? They very briefly, just a very cursory thing in what's called the Federal Register that said, well, that's close enough for us to figure it out. That was actually approved in May of 2012. And then subsequently, some of us thought that might be a problem legally, and time to move ahead on that.
Isn't there a legal provision for something that's vague or confusing in a law and that the executive branch has a right to interpret it?
Yes. In private contracts, there's actually a rule on ambiguity construed against the person offering the contract. This is a court doctrine in terms of interpreting administrative rules, basically. The short version of it is it's called the Chevron doctrine from a case in the I think early 1980s. It's not about Hugo Chavez offering free heating oil to our good friends of Joseph Kennedy or others. And basically the takeaway from it was in cases in which it's ambiguous, unclear as to what Congress meant. Which happens. It can happen. Then if there's a reasonable construction by the executive branch agency, which is delegated to interpret it, it's more than tie goes to the runner. It's a little bit of almost a bias toward, yeah, that's close enough. Now, that's if you get to that stage of the Chevron analysis after you first looked at the text and what the underlying history is. Say, it's pretty clear cut. We don't have any ambiguity here. This is what Congress meant. So it's not in any way a slam dunk or a bias. So the question in this case is, what did the actual law that was passed, the language that most applies, is there some problematic ambiguity, and is some construction less plausible or more plausible than another before we get into overtime, which is to basically say, well, the IRS kind of, they do this even though they didn't have to do this. That's why there's been some splits in the lower courts when they can see it one way or the other. So the Supreme Court's
got to work all this out now. That's basically what's at stake.
Well, they have to find 5 votes for something and then write the opinion after they've got the 5 votes. It probably works backwards. You hear the oral argument, it's interesting, and you go, well, he might mean this. The eyebrow was raised over here. That was a funny little rebuttal. In most cases, they've already read the briefs before even the oral argument back when we had it in March, and they pretty much know how they're going to vote. Not always. There can be an exception, but it's a good show, and they have fun doing it. And then they take a vote about within a week later to the next conference.
And they keep that a secret.
And every once in a while, a justice changes his or her mind, as we saw in the individual mandate case. At least that's the general, although it's all supposed to be secret. And sometimes it's hard to get 5 people to agree to the same opinion. There's also that type of horse trading type thing. So that's where we are in terms of the legalities. The best prediction, I'll go out on a limb from a different date, is timing. Is it's most likely to be June 30th, the very last day of the court term. Could be earlier, but not likely. And I'll give you the bonus prediction, which it'll probably be the same day that the same-sex marriage decision is also announced. Maybe a 1-for-1. We give you this, we give you that back in return.
There's some real politic going on there, isn't there?
It'll divide up the folks a little bit.
So before we move on to the consequences of the decision as it goes one way or another to healthcare, what's the consequences to the rule of law in general?
This is a continuation of a pattern of conduct, is how I would put it. There's actually a very good amicus brief filed in the case by friends at Cato Institute, which talk about this is not the first time this has happened. This is a very bad example of it occurring, but there have been a number of provisions within the health law itself that either have been suspended. Remember the employer mandate that got parked? That was actually literally was done by a blog post on the 4th of July weekend. And they did another change of it over Memorial Day weekend and another type of amendment to their blog post. But there have been a bunch of other provisions which they weren't working. They couldn't work. So they either weren't enforced, they were delayed, or they were redescribed as something else.
Law on the fly.
Law on the fly, and if you don't like today's law, we'll give you tomorrow's. Now, that extends beyond just the area of health law into other areas.
Tax,
because we
trade.
have the modern government is the administrative state. Congress writes kind of some vague words, and then it turns out that people go to work as to put it into practice or into some other kind of practice. There are financial regulations, Dodd-Frank, that go in that direction. Environmental regulation has been a playground for this type of thing as to whether that particular, provision in that element is or is not a pollutant, et cetera.
So if the Supreme Court comes down on the government side here, it's really an invitation to do more of the same.
It's an encouragement to further recidivism without any penalties. Now, the Supreme Court has been good on this lately. There are a number of opinions just within the last year of the previous term, pulling the administration back in check. One in the environmental rules area, utility air. Another one, which is actually a state government case, but has broader precedence on that front to basically say, if you pass a law that doesn't work or doesn't say things the way you wanted it to, go fix the law, as opposed to let us interpret it creatively in order to fit it along.
So, Tom, you predicted that the decision will come pretty much at the end of the Supreme Court session. Paint a picture for us of the two possible futures, depending on which way the decision goes.
It's a less exciting story if the Supreme Court says, we do this all the time, close enough, let's move on.
Business unusual, get used to it.
No accident here, nobody collided with anyone, and, just move along. And besides, it's too hard to upset a law that's been in effect for 4 or 5 years.
Do they think about that a lot?
Not in their better moments. There are all kinds of mixed reasons to go into a Supreme Court
we had
decision.
slavery for a lot of years, and they overturned that.
Correct. And sometimes the view of the law changes. Sometimes there are some practical consequences which shape that. And let's be honest about this. Although the justices try their best, they usually come with a certain view of the world. And there's not only a legal view of the world, but sometimes there's a little bit of consequentialist, what does this mean, thinking that goes into it. The government has been manufacturing a bunch of arguments, not only about what the law is, but the dire consequences if, in fact, the plaintiffs in this case won and the subsidies were taken away from the exchange. We'll park that over to the side. So that can be a factor. The arguments in the previous individual mandate case was that Chief Justice Roberts was concerned about, controversy and the court overstepping its bounds and standing in the way of a popular president.
Yeah, will it lose its credibility with the people?
Et cetera, until the next New York Times editorial comes out. So I was saying, the world in which, basically, if there's not just a yellow caution flag, but a green light, the administration go ahead with continuing to implement the law in this way, there will continue to be some efforts to curb or restrict or limit the reach of the law, but it'll be a big win for the president. And you'll have to actually do some hard work, both politically and the policy front, to change what is an ongoing installed base enterprise, which means a lot of power for the government over health care and a lot of money going back and forth.
And would it also validate the strategy of creating as many entitlements as possible quickly to put people dependent on the government so that they're afraid to take those entitlements away?
Well, that's the broader political theory, which is I sometimes refer to this as the Brezhnev doctrine, which is, once you've captured the territory, you can never be liberated, and there's no rollback. And certainly the modern entitlement state has a long history of saying as soon as people get a taste of something, you can't take it away from them. Some of these subsidies are very large. They're very stacked toward lower income beneficiaries, but not entirely. But they're more generous than a lot of things have been before. So that creates the dynamic of political dependency. Who gave you this to you? Who's trying to take it away from you? And you'll vote for us. In fact, et cetera. So that's the basic package there. We know the mix from that.
Before the show, we were talking about the Santa Claus theory of government. Remind us about that.
Well, this is Republicans are never, saintly, and Democrats are never totally evil, et cetera, despite what some may contend. They're both politicians. And the question is, how do you get people to support you and be grateful for what you've done for them? So there's an older theory that goes back to early supply side days promoted. It was called, we got a problem. The Democrats keep offering to spend more money and buy more votes. And what can we do as
more
Republicans?
Goodies, right.
We'll say we can do it cheaper or we won't do it as much because we're fiscally disciplined. Instead, the two Santa Claus theory says we need to give something else of gifts to people like Santa Claus. We can't outbid them through the spending arm of government, federal government. We'll do it through the tax code. So we'll give people people tax cuts. That's another way to give them a benefit, and we'll compete on that basis. And that's the two Santa Claus theory of government. And to some extent, we've seen that in healthcare, where Republicans in office often will say, well, we'll give you a tax credit or we'll give you a type of subsidy for your healthcare, as opposed to the Democratic approach to a different type of entitlement.
So you've painted a picture of business as usual if the administration wins at the Supreme Court. A lot of people have said there'd be tremendously dire consequences and ripple effects if the court strikes down Obamacare. Paint that picture.
Well, those violins have been played by others, but the short version is the day after, if you will, nuclear holocaust, biblical disaster of apportionment, et cetera. Suddenly, no one who previously could get easy health care that was subsidized in one of these federal exchange states, and there could be as many as 37, depending on how you count them up.
And maybe 5-6 million people we're talking about here, right?
Right. And so first their subsidies are stripped away, which means in this painted scenario,
they pay full price,
which would be terrible to see what it actually costs, but also that quickly they would drop their coverage. The only folks who would remain in these pools of the exchanges would be people who were desperate and had very high costs.
So the adverse.
I've been dealing with these buzzwords forever: adverse selection, death spirals. Death spirals usually caused by government regulation, but we don't bring up that point. It's all just due to that. And insurers would suddenly either drop out or wouldn't be able to make ends meet because the prices wouldn't be right. And then the hospitals, of course, start
to fold.
They would fold because they have all these uncompensated. It would be just terrible.
And dogs and cats would be living together. But
the end times. Although, amazingly enough, 2009, 2010, before the law passed, I guess something existed before then that weren't quite the end times for the law.
I could never understand. Going back to 2005 doesn't seem like the worst calamity in the world.
And the law was passed by this benevolent Congress and administration a couple of years ago, and yet they didn't provide all this for 3 or 4 years while people were dying and not having health care. So it's interesting they could wait that long before turning the corner. So that's the dire picture. Unrealistic. It's not going to happen that way for a number of reasons, aside from the practical consequences of what would happen in a less subsidized market. There would be other moves.
Will Congress step up and write some new laws? Or
Congress might do that. In fact, they've been working on that for some time. It's not easy to do that. No one said it wasn't easy to pass this law. And certainly the first instinct is to say it's someone else's problem, pass the buck to someone else, whether it's a state official or members of Congress. But I always believe in the remarkable ability of politicians in office to want to stay in office. And if they have no other alternative but to fix the problem they wanted to avoid, they will do so.
They'll figure something out.
So I would expect within, a day, if not hours, of Supreme Court ruling after respective people jumping off a balcony or jumping for glee, that there would actually be some legislative moves pretty quickly, because people are working on it in the background, to provide a fix. And the Republicans would be very unwise not to be offering something pretty quickly, which makes things better rather than worse. And that's the important ingredient. Don't just reestablish what you already had that you were trying to change.
What's to prevent a state legislature who currently has a federal exchange from just passing a law deeming the federal exchange to be state established?
Well, they could try that. There are a number of reasons. The way the law is written, occasionally honored in the breach, there's some hurdles you have to get through to qualify as a federal exchange, even in this permissive environment. Now, there will be definitely some administrative workarounds. There'll be some efforts to try to contract out things that the state has to do. I understand that. They need legal authority to do that, to set up the exchange. And in that case, in a number of states, there's either a law that says you have to go through the state legislature to approve it. The government can't do it on its own. Or there's budgetary restrictions where they can't have enough of a food supply to actually do the preliminary steps. I would expect that anywhere from a half dozen to 10 states will try that route, though, and some will succeed, because with this administration, the day before, or months before, actually, they were saying, we can't do this, there's no fix. They said that right before oral argument. Well, the day after the decision comes down that's against them, as they used to say in the Nixon White House, or you remember Ron Ziegler, that information was no longer operative. We just changed that. And on top of that, they'll be saying, so what's your problem? You're going to sue us? Well, we'll get back to you in a couple of years, because you can't get an immediate judicial relief even if they do something illegal.
I don't understand that.
That's the problem of permitting all this made-up-on-the-fly administrative guidance.
Don't those subsidies have to stop within 30 days or something?
That's what the rule of law would say, and that's what the Supreme Court would say. I'm not saying explicitly they'll say we're going to thumb our nose completely at the court. We'll do it through a different manner by saying that the old federal exchanges can be called state exchanges. We've changed the rules that we had set down. All the old deadlines don't apply. this has been done by this administration before, and I think it will probably be attempted soon.
So then you have to start suing all over again?
That's my point. And when you do that, you don't get a lawsuit the next day. You have to,
find
this
plaintiffs,
is why Competitive Enterprise Institute was so good at this, but it took a long time to do it. You have to organize your arguments. You have to have plaintiffs who are real and actually have an injury. You have to go through a lot of procedural motions even to get into court and stay in court. And then you got to go through 2-3 levels of court in order to get a final decision. You won't get a stop right there instant injunction. So that's why we need to get this back into regular politics. We can play legal games and back and forth. At a certain point, you want to have a little good faith by all people, but those bounds have been stretched. So if we can get this before Congress where not everybody's going to be happy, you're going to take a vote. You're not going to get everything you want.
Take 60 votes, right?
Probably.
To make anything happen.
There's some arguments that you may be able to do this with 50 votes through reconciliation. I wouldn't want to...
that's what they did last time, isn't it?
They fixed parts of the law with reconciliation. They didn't pass the entire law. That's arcane, but it could be an issue. It may not be an issue. There are different points of view as to how that can be wired. In any case, what you have to do is you have to find the majority that exists today. There was a majority back in 2010 when this lost. That majority's not around anymore. There have been a couple of elections which made that pretty clear. So we're stuck with a law which a lot of people don't support, don't like, and Congress has been frozen, and it's time to unfreeze it. And a court decision that says, you can't change a law that you didn't pass. It's your job to fix it. We'll put it back in the hands of the people who have to be responsible, if they don't want to be responsible, the members of Congress, and they're going to have to come up with a conclusion and a compromise, which makes things better, not solving every problem, but leaves people a little unhappy, and that's what the nature of a political compromise is.
Isn't expecting Congress to step up to their job and act competently a lot to ask?
It's a lot to ask, and it's only in the situation where they have no other alternative. But I think in this case, they will have no other alternative, and they will do it. And the president, even though he doesn't want to agree with the Congress and will hold off and posture, he'll also have to agree to something. This is like the inevitable result of being caught in a corner. They love to do something else that passes the buck, but they will be left with having to do their day job.
And assuming they do step up, which would be quite amazing to see, could this have an impact on other laws like Dodd-Frank and some of the other messes that have been made by past Congresses? It
would be a strong signal. Why people we're thinking of the politics, back in the winter or the spring and how this is going to play out, and they didn't think about what it might look like after a court decision, which you just said, this administration did something illegal. Or the IRS, who we all love. Could they possibly do something illegal, spy on people? No, they wouldn't ever do that. So it changes the perceptions as to, and there's obviously been a lot of antipathy to the law, but it says, this provision, you just took us on a ride, a joyride, if you will, and a lot of people are going to get hurt, and who really caused that to come about? There are some consequences, practically speaking. Without the subsidies, or at least under the old structure, you don't trigger. So these are practical things. The individual mandate for most people, because suddenly the insurance is more unaffordable without the mandate. More people are exempt from it. The employer mandate can't be enforced. This is the way the law is written.
Sure, there's a lot of pieces that fall apart.
A lot of pieces, and it begins to change the dynamics of insurance regulation, where we will probably have more of a focus of it being state-based with a wider latitude for products that people are willing and able to buy, as opposed to what the government has said, here's what you can purchase and someone else will pay for it.
Regardless of what the Supreme Court ultimately decides, is it fair to say this will still be an issue in the 2016 presidential election?
Yes. I'd say that if the Supreme Court knocks out the IRS rule, there's still a lot of work to do to begin to transition to a better type of healthcare system and set of arrangements, and that work can't all be done just by cleaning up this short-term mess. On the other hand, if the Supreme Court validates this approach, there's a bigger hurdle for the folks who are upset about this to try to overcome that. The presidential race will address these issues, but a lot of things will have been instituted and put in place where it's harder to roll things back after they have even further momentum of more victims being tied to the railroad tracks as hostages.
And if the Supreme Court does validate the administration's ability to pretty much make up law as it goes along.
Oh, they'll stop right there. The administration wouldn't do anything beyond that, would they?
But what happens when the Republicans get in charge?
Well, that's correct. That's the flip over.
Shouldn't you be worried about that if you're a Democrat?
You should be. Politicians are not known for their long-term vision beyond the next election, but that's certainly correct. That what's works for one side will work for the other side, and a Republican president could begin to use wide-ranging executive branch discretion to redefine terms, and all of a sudden you've got a different law than the one you thought you had a year before. ultimately there's certain bounds to the extremes. So they've been stretched here by natural politics. You won't do something that's broadly unpopular. Well, they did pass this law, now that I think about it. But it does provide a wider latitude of a little bit more of a Latin American approach to U.S. government, where whoever's in power gets to write the rules.
Well, let's hope the Supreme Court is as wise as they might be sometimes, sorts this out for it, and we don't end up going in that direction. Tom, thanks so much for being on the show.
You're very welcome.
That was Thomas Miller, resident fellow at the American Enterprise Institute, here on Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. Check us out on Facebook or follow us on Twitter at Real Clear Frezza. And stop by RealClearMarkets.com, my go-to place for diverse views on political economics. Ahead, we'll read the oral argument tea leaves on what may be this session's most closely watched Supreme Court case with Carrie Severino from the Judicial Crisis Network. Stay tuned.